Namaste. The present amendment to the Insolvency Bankruptcy Code, which was first introduced in December 2019, has come about at a time when further amendments would probably be necessary. There should be a quick run-through of the amendments, the intent behind each such amendment and its implication. The expectation and the apprehensions shall also be touched upon. The Ministry of Corporate Affairs, by its notification in March 2020, had incorporated amendments to the Insolvency Bankruptcy Code. The changes made in the latest amendment are starting from Section 4. Now, Section 4.1 deals with the minimum threshold for default. Prior to the amendment, Section 4.1 permitted corporate debtors to move the tribunal wherein the amount of default was 1 lakh and above. Post-amendment, Section 4 permits creditors to move the tribunal wherein the amount of default is 1 crore and above. The threshold for default has been raised from 1 lakh to 1 crore in order to prevent filing of insolvency proceedings against MSMEs or small-scale corporates. The timing of the amendments could not have been any better. In view of the pandemic, keeping in mind the companies would face immense difficulties, the amendment in favor of MSMEs who face the wrath of creditors during this situation is a welcome sign. It is also seen that most cases have been filed by operational creditors whose claims are lesser as compared to the financial creditors. The amendment aims at curbing the filing of frivolous applications. Therefore, the corporate debtor would be at an advantage because of the amendment, while some operational creditors would suffer. Such an amendment would result in increasing the burden of the civil courts, the recovery courts. The creditors would have to face a long-standing trial before their dues are recovered. The amendment brings relief to the companies who are unable to pay their debts and allows them an opportunity to revive as a company. However, the companies below this threshold who have been perennial defaulters get away scot-free, and the operational creditors who have all along been the ideal bank, say probably banks, besides the banks, they're all left now in the lurch. It is imperative to take note of the fact that raising of the threshold is a prospective change and cannot be a retrospective change in its nature. In the case of Syndicate Bank versus Bhadreshwar, wherein an application was made by a financial creditor with just about 1.5% of the total financial debt, insolvency process was ordered on a technicality merely because the amount due exceeded the monetary threshold, which was then 1 lakh. Therefore, in order to avoid the confusion over the retrospective or prospective effect, clarifications can be made with respect to cases wherein a demand notice under 8 of the IBC has already been delivered to the corporate debtor in the matter set out in Rule 5 of the IBC, that is the rules of 2016. In such cases, would pre-amendment or post-amendment be applicable, wherein a demand notice has already been delivered to the corporate debtor irrespective of the amount that is due. Now, Section 5, Subsection 12 deals with insolvency commencement date. Now, prior to the amendment, the commencement date of insolvency was from the date on which the IRP was appointed by the court if the IRP was not appointed on the date of admitting the application. With this amendment, the entire proviso has been removed. Therefore, in sync with the amendment, that is the proposal in Section 16, the amendment bill has gone back to the earlier form to provide that corporate insolvency resolution process shall be deemed to commence from the date of admission and not from the date of appointment of the IRP in case the two differ. While there have been very few cases where such time lag has existed, it may be noted that wherein it may happen that the IRP is not appointed on the same day of admission, then it becomes necessary to consider that the CIRP process commences only from the date of the appointment. Therefore, to remove this anomaly, this amendment has come. Section 5, subsection 15 deals with interim finance. Now, prior to the amendment, the definition of the interim finance meant any financial debt raised by the resolution professional during the resolution period, the process period. Now, post-amendment, the definition includes such other debt as may be notified raised by the resolution professional during the insolvency resolution process. Now, the scope of interim finance has been widened so as to leave open any inclusion as may be found necessary. In view of the amendments with respect to identification of essential goods, it is expected that the term such other debts shall include debt for ensuring availability of the essential goods which may be identified by the RP as critical. Now, Section 7. Section 7, application by financial creditor. Prior to the amendment, this section did not contain any provisos. Post-amendment, several provisos with respect to application by the financial creditors were inserted. There was application for initiation of corporate CIRP can be filed only when such applications filed jointly by at least 100 such creditors in the same class, or 10% of the total number of creditors in that class, whichever is lesser. In case of application by allottees of real estate projects, application has to be jointly filed by at least 100 such allottees under the same project, or 10% of the total number of allottees of the very same real estate project, whichever is less. Now, when the application by such creditors as mentioned is not admitted before the commencement of this Amendment Act, the application is required to be modified in terms of the provisions now, failing which it shall be deemed to be withdrawn before the admission, which means that the existing cases which have not yet been admitted will have to be amended accordingly. This amendment was done to mitigate the risk of frivolous applications while also keeping the door open for genuine parties. In the context of home buyers, the applicants shall file only if related to the very same real estate project. For example, one particular developer has two simultaneous projects going on, even probably next door. But they can move only if they have invested in one particular project. Now, you can't combine a few from this project and a few from the other project and say we are 100. Therefore, if a company has several real estate projects floating, the allottees can, across the projects, to fulfill the threshold criteria to initiate the application. So, they cannot basically try to combine both. It's important to note that the provisos have to be complied with in cases where applications have not been admitted yet. Additionally, for applications already admitted, the admissions cannot be reversed. The provisos are not retrospectively applicable since it's not explicitly provided for in the amendment. In the context of real estate, the purchasers, that is the flat purchasers, as per the amendment, are now considered as financial creditors. And if a large number of them are represented by one nominated person, that authorized representative shall be part of the COC when it is constituted. The objective was to make it easier on the financial creditors, as there are more operational creditors normally moving the NCLT. Home buyers who cannot garner the numbers, that's basically what has been a worry for a lot of them. So therefore, home buyers who cannot garner the numbers and have invested in a very small project, they may seek legal recourse under the Real Estate Regulation and Development Act. Section 11. Now, Section 11, persons who are not entitled to make an application. Now, prior to the amendment, this section did not contain any clarification with regard to any person entitled to make an application. Post-amendment, a clarification has been added, wherein it says that it's clarified that nothing in this section shall prevent a corporate debtor rendered ineligible under this section from initiating a CIRP against any other corporate debtor. While it was widely accepted that Section 11 of the Code did not restrict a corporate debtor from initiating insolvency against another corporate debtor, there were instances where the right of a corporate debtor was denied by the court on maintainability. Therefore, in order to establish the true intent and to remove the anomaly regarding validity of an application filed by the RP or a liquidator or of a corporate debtor against another corporate debtor, the amendment bill has provided such clarification. Therefore, an application can also be moved by an IRP, RP, liquidator or a respondent applicant. Now, Section 12. Section 12(1), amongst several additions and deletions in these amendments, under 12(1) an amendment was made wherein it is stated that any resolution process shall be completed within 180 days. The extension of 90 days is to be permitted if approved by the NCLT. The resolution process shall be completed in 330 days and an additional 90 days shall be provided only in exceptional circumstances. This period of 330 days would include a normal CIRP period of 180 days, a one-time extension if required, up to 90 days of such CIRP period granted by the court, and the time taken for the entire case. Now, Section 14 deals with the moratorium, wherein prior to the amendment, this section did not contain any clarification. Post-amendment, a clarification states that a license, permits, registrations, quota, concessions, clearances, or a similar grant given by the central government or the state government or a local authority. Now, all of this cannot be suspended or terminated on the grounds of insolvency. This was subject to the condition that there was no default in the payment for licenses, permits, or registrations. Now, in order to allow the smooth functioning of businesses even after the commencement of the CIRP, the amendment bill protects the corporate debtor. This protection comes with a rider that the corporate debtor has not defaulted in payments towards these licenses during the moratorium period. 14.2. Now, 14.2a deals with essential goods and services. Prior to the amendment, this subsection did not exist. Now, post-amendment, the newly inserted 14.2a provides that a supply of goods and the services which are as per the RP's discretion are essential to keep the corporate debtor a going concern and to protect and preserve the value. Basically that nothing shall be terminated or suspended and cannot be interrupted only because insolvency process is already commenced. This again comes with a rider that such goods and services may not be stopped if payment towards the same has not been made by the corporate debtor for supply during the moratorium period or in such circumstances as may be specified. The addition to this subsection effectively leaves it upon the discretion of the resolution professional to decide which goods or services shall be construed to be critical in nature without providing any parameter or guidelines based on which this could be determined. This gives a very large scope for the RP to decide. Now, Section 14.3a deals with the inapplicability of the moratorium. Prior to the amendment, this subsection stated that it shall not be applicable wherein a transaction has been notified by the central government in consultation with any financial regulator. The post-amendment, the subsection substitutes it with it shall not be applicable to any such transactions, agreements or arrangements as may be notified by the central government in consultation with any financial sector regulator or any other authority. Now, in order to make sure that the scope of the moratorium does not cover a wrongful transaction by the corporate debtor done prior to the commencement or during the CIRP, the scope of these transactions have been widened from consultation with financial regulators only to other regulatory authorities also. This will basically provide for a much larger coverage of transactions on which benefits of moratorium basically cannot be enjoyed. Section 16(1) deals with the appointment of the IRP. Prior to the amendment, it was to be appointed within 14 days from the insolvency commencement date. Now, post-amendment, it is to be appointed on the IRP is to be appointed on the insolvency commencement date. Corresponding with the amendment which we discussed in section 512, the amendment bill now requires that the IRP be appointed on the date of the insolvency commencement date itself. Section 21. Now, section 21(2) deals with the committee of creditors. Prior to the amendment of the second proviso read that provided further that the first proviso shall not apply to a financial creditor regulated by a financial sector regulator if it is related party of a corporate debtor solely on account of conversion or substitution of debt into equity shares. Now, the post-amendment provided further that the first proviso will not apply to a financial creditor regulated by a financial sector regulator if it is a related party of the corporate debtor solely on the account of conversion or substitution of debt into equity or instruments convertible into equity. Now, conditions on which a financial creditor shall not be considered to be a related party of the corporate debtor has been widened, bestowing on the government the right to prescribe such transactions on the completion on which a financial creditor may not be considered a related party. Section 23(1) deals with the office of the RP. The amendment has clarified that the affairs of the corporate debtor in between the period of the conclusion of the CIRP and the implementation of the successful resolution plan, commencement of liquidation shall not be the responsibility of the RP only. However, the law is still silent on the status of the COC. Therefore, once the resolution process is complete, it does not end there. He continues to be an RP until the resolution plan is complete. Now, section 29. Ineligibility to submit a resolution plan. Conditions on which a financial creditor shall not be considered to be a related party of the corporate debtor have been widened, bestowing on the government the right to provide or prescribe such transactions in completion of which a financial creditor may not be considered to be a related party. This in turn narrows the scope of related party of a resolution applicant for determining the eligibility under section 29A of the Act. Section 32. Now, section 32A, the liability for prior offences. This section provides for protection from the liability of a corporate debtor in respect of offences committed prior to the commencement of the corporate insolvency resolution process, subject of course to certain conditions. This amendment protects successful bidders from criminal prosecution for offences committed by the company's erstwhile promoters. The latest amendment also attempts at keeping potential frivolous litigators at bay. Therefore, individual home buyers are protected. The liability of subsequent interested parties are protected. Therefore, there are several protections which have come in by the amendments now. Section 227 has come in. This basically gives larger powers to the central government to notify any financial sector providers. The amendment comes in as an obligatory change only to incorporate the provisions for initiation of application against the financial service providers read with the insolvency and bankruptcy liquidation proceedings. 239, again powers to make rules, wherein the amendment empowers the central government to set out rules to make any amendment with respect to the amendment bill. That is, the central government will, by way of rules, prescribe the transactions on the completion of which a financial creditor will not be treated as a related party of the corporate debtor. Now, section 242 also with respect to powers to make regulations. This is not with respect to the central government, this is with respect to the board. So the amendment empowers the board to set out regulations with respect to the changes as provided for in the amendment bill. These were with respect to the amendments. Coming to the ordinance. With respect to suspending sections 7, 8 and 9, a proposal to promulgate an ordinance to suspend insolvency proceedings against new defaulters for 6 months has been made. Keeping in mind the present situation in the country, an ordinance to suspend sections 7, 8 and 9 and keep it in abeyance is being deliberated upon. In order to prevent the increasing number of defaults by various enterprises amidst financial distress faced by companies due to the COVID-19 pandemic, the Government of India on 22nd April 2020 proposed to introduce Section 10A under the Insolvency Bankruptcy Code with the objective of suspending Sections 7, 9, 10 of the Code dealing with the initiation of the corporate insolvency resolution process. This suspension denotes a bar on the ability of a financial creditor, operational creditor and a corporate applicant seeking initiation of CIRP for a period of 6 months but not exceeding 12 months. The said ordinance aims to suspend 7, 9 and 10 to safeguard borrowers from being dragged into insolvency. Section 7 allows a financial creditor to file for initiation of corporate insolvency process. 9 provides for an applicant of insolvency by an operational creditor, and 10 is for initiation of proceedings by a corporate applicant. Now, it is pertinent to mention that financial creditors have other legal avenues to recover their debts, such as under the SAFEZI Act or under Recovery of Debts Due to Banks and Financial Institutions Act. Therefore, the interests of operational creditors seems to have taken a backseat, whether it's with respect to the amendment in March or probably the ordinance. Now, the appointment of IRPs require a complete overhauling and specific rules with respect to the role, the powers, and the scope of their work when a company is taken over. These may be required is what is the opinion of several experts, lawyers, and all those who are before the adjudicating authority under the IBC. The unrestricted power to deal with the assets of a company rests with one single individual. Nothing further needs to be said on this aspect except that subsections 27 of section 5 of the IBC requires to be amended despite the fact that the Supreme Court in Swiss Ribbons had clarified that the administrative functions of the resolution professionals are subject to judicial supervision. With the recent amendments and the proposed amendments, we could all expect a Swiss Ribbons Part 2. Namaste.